Bonjour, bonjour à toutes et tous. J'espère que vous allez bien. Je commence en français. Je vais aller en anglais dans quelques secondes. Bienvenue dans cette conférence qui va porter sur les dimensions reliées au travail dans l'accord entre le Canada, les États-Unis et le Mexique. Il me fait plaisir de vous accueillir dans cette conférence organisée par le Centre d'études sur l'intégration et la mondialisation. Et maintenant, je vais passer en anglais pour introduire notre invité. To begin, just a few words on the subject. We have now nearly 30 years of experience with institution linking trade and labor agreements. The first one was NALC, the NAFTA side agreement dealing with labor norms. This first side agreement made unanimity against itself because of its incapacity to provide real change in the labor right practices of the member states. But the labor and trade institutions have changed a lot since the 90s. To date, more than 150 trade agreements include labor obligations in North America, Canada, and the US have committed to reinforce labor right mechanisms many times from NALC to now. What we can wonder if that the new CUSMA model is just another improvement of last labor and trade mechanism, of if we face a little revolution in the way to link labor and trade. In particular, a new rapid labor resolution mechanisms for collective labor rights seems to be a promising way to support workers in their process to obtain real rights to unionize and bargain collectively, particularly in Mexico. Making my research on these topics for long years, it's the first time I see employer organizations and employer attorneys saying to business leaders, warning make change in your strategy in Mexico territory, the change in the labor, the trade agreements needs you to change your practices. So I'm really pleased and glad to welcome Sandra Polaski to give us a conference on the subject, CUSMA, a new generation of social clause. Let me introduce Sandra. She's an expert on trade and labor and social policy issues at national and global levels. She directed the Trade Equity and Development Program in Carnegie Endowment for International Peace. After that, she was US Deputy Undersecretary of Labor in charge of International Labor Affairs Bureau. And she served as Deputy Director General for Policy in the International Labor Organizations from 2012 to 2016. And as ILO Sherpa to the G20. And after that, now she's a non-resident senior research scholar on Global Economic Governance Initiative at the Boston University Global Development Policy Center. She's a member of congressionally appointed Independent Mexico Labor Expert Board. So thank you, Sandra, to share your point of view in this conference.
Thank you very much, Sylvain. I'm very happy to be here with also seeing some other friends that I haven't seen for many years, Pierre, Pablo, etc., for this conference. I have prepared a PowerPoint because there's really a great deal of material to cover, and I would like to help keep it organized, including for the audience. So here we are. So the next slide, please, Eric. So I would organize my remarks around 4 main topics or questions. First, trying to set the context. Why were labor issues so salient in NAFTA during the renegotiation of NAFTA and now in the USMCA? First question, the context. Second, what are the key changes and innovations in the USMCA labor chapter and enforcement chapter? Third, how are the labor obligations being implemented by Mexico and how are they being enforced under the agreement? And finally, does USMCA represent a new generation of labor and social clauses? Is it a model for future trade agreements? So I will try to cover those 4 areas, and in many cases, I'll invite you to come back for more detail if you would like to have it. Next slide, Eric. So first of all, for the context, starting with NAFTA, it's important to remember and to note that NAFTA was designed to create a continent-wide production platform to improve North American competitiveness. Well, to improve US competitiveness was the original strategy of the Bush administration, but let's say North American companies at a time when the competition with Japan in particular and Germany was increasing. And so the notion was this free trade agreement would create a continent-wide production platform. So in a certain sense, it was a deep integration agreement, but only for production. There was no social acquis as in the European Union. There were no fiscal transfers as in the European Union. So it was a sort of deep integration for production and investment, but not for social balancing issues. It also was the first full free trade agreement that the US, or really any country, had negotiated with a developing country. And economic theory predicts that in a case where markets are opened at very different levels of income, if the technology is shared, in other words, if it's mobile, there will be convergence of factor prices. So labor costs will tend to converge with declines in higher wage countries and increases in lower wage countries. However, Mexico from the early 80s, when the government there took a neoliberal turn, followed a policy of wage repression in various ways, which will come up in our conversation about the current situation, which meant that Mexican manufacturing wages did not converge upward. Next slide, please. Eric, this is just a quick look. This was prepared by the ILO for its global wage report, and it happens to look at the emerging G20 economies. But what's interesting to note there is the bottom line, the sort of burgundy colored line, is Mexico. This is 2008 to 2019, just because we always did our global wage report for a 10-year period. And what you see is that real wages actually declined in Mexico over that entire period, in contrast to any of the other emerging or developing G20 economies, all of which went up. Most dramatically, China, which actually beginning before 2008, in 2003 began a policy of very dramatic wage and minimum wage increases. But so Mexico did not converge through a conscious policy choice. Can you go to the next slide, please? So that's sort of the background. Well, what was the actual labor market experience that happened then under the 25 years that NAFTA was in effect? It's not simple to be able to say so many jobs were gained or lost at the aggregate level, partly because there are so many different features of NAFTA, some pushing in different directions in terms of labor demand, and other factors going on that could confound the results. But what can confidently be said now, based on more recent research, is that in the US, there was a very significant negative wage effect for those US labor markets that were most exposed to competition with Mexico. There have been a number of studies over the last 10 years or so that use richer data sets that are available and computing power, and the results are quite dramatic, that in those labor markets, meaning metropolitan areas that are labor markets, the effect was very negative on wages, and it's spilled over into reduced bargaining power for workers, and negative effects on their communities. In Canada, much of the adjustment occurred under the Canada-US FTA, not so much under NAFTA, partly because of the years of experience from 89 until 94. There were several important studies that were done relatively early under NAFTA. Treffler is a good source that found that in the industries that were most affected by the Canadian tariffs, there were the employment fell by 12% over the first 7 years, and overall there was a loss of manufacturing employment. which recovered partly but never fully. In Mexico, as I said, the wage convergence did not happen because of wage repression policies, which were both collective bargaining policies of wage repression and also minimum wage policies. And again, we'll come back to those. So in 2018, just before NAFTA ended, Mexican manufacturing wages were still about 10% of those in the US, which was the ratio that existed before NAFTA was negotiated. So there was no convergence. There was also very significant displacement of agricultural labor in Mexico in the early years of NAFTA due to the opening of agricultural markets. Well, that increased the labor supply of people who were looking for jobs that went into manufacturing, services, and of course, a lot into the informal sector. So that was just a quick sketch of what actually happened in the markets. And I can recommend in the new book edited by Michelle, NAFTA 2.0, in the conclusion chapter, we go into these results in much more detail if you're interested. Next slide, please. So why was a stronger labor chapter essential in order to reach an agreement on a replacement for NAFTA, the NAFTA 2.0 or USMCA? Well, in the US, and many of you probably followed this at the time, there was a narrative about NAFTA that became widespread and consolidated, that NAFTA was a source of wage decline. As I said, it truly was in the most affected communities, but not necessarily at the aggregate level. But that narrative became broadly accepted in the country, and it was effectively used as a political weapon by candidate Donald Trump in the 2016 presidential election. And he promised during that election that if elected, he would replace NAFTA, and proceeded to do so. And his negotiators did in fact deliver a stronger labor chapter, partly based on incorporating updates that had happened to NAFTA in the 25 years of its existence. And I'll come back to that when we talk about the changes, and partly based on some side negotiations that took place between US and Mexico during the Trans-Pacific Partnership negotiations. So during those talks, the US insisted that Mexico would have to agree to labor reforms in order for the US to agree to its accession to TPP. And actually, the changes that made it into the USMCA in terms of Mexico's commitments in the annex to the labor chapter had already been agreed in principle. And indeed, Peña Nieto, the then president, had introduced them as reforms, as a constitutional reform that had been adopted by the Mexican Congress. It had been sent to the Mexican states and was in the process of being ratified by all the Mexican states, almost exactly at the same time that Trump took office and pulled out of the TPP. But now there had been this constitutional reform in Mexico, and those terms were in USMCA. So that agreement was signed in, I believe it was December of 2018, late 2018, by Trump and Peña Nieto and already Trudeau. But two concurrent and momentous political changes occurred about the same time. One was that in the election in November of 2018, control of the House of Representatives switched to Democrats. The House of Representatives controls the trade ratification process, timing and initiation, and they vowed not to ratify USMCA without significant changes, particularly in terms of the labor obligations and the enforcement mechanism. And in December of 2018, Andrés Manuel López Obrador took over as the president of Mexico with a very different political philosophy and political base than what had existed before. Next slide, please. So what actually then changed with these forces coming to bear on the agreement? What are the key changes and innovations that are made in the USMCA labor chapter? Well, first, USMCA incorporated changes and updates to labor chapters that had been made by the US and made by Canada in those 25 years between NAFTA and USMCA. Michelle likes to call that the second generation of labor clauses, and I think it's probably a good name. Those changes evolved based on experience, based on discontent. Sylvain referred to that. Nobody was happy with NAFTA. And so partly it was the discontent and and the desire to make improvements and some experience, lessons learned. But in the US case, I can tell you that the changes were made primarily as the result of shifts in the political balance of forces in the White House and Congress. As the White House shifted parties and the Congress control of the House of Representatives shifted parties, those were the main drivers for the changes that the US made. So USMCA incorporated all those changes US and Canada had made. And if you want to talk about them later in the discussion, we can. But the important thing is that NAFTA, USMCA rather, innovated in 4 main areas, things that had not been done in any trade agreements before. First, it required specific, significant, and enforceable changes to the Mexican industrial relations system and the reform of its labor law, as already had been started through the constitutional reform process. Second, it created a brand new enforcement mechanism, the rapid response mechanism, which we'll talk about in detail. It added innovations dealing with anti-union violence, right to strike, migrant workers' legal protections, and gender discrimination. And it remedied some very big loopholes that had been found in previous FTAs that made them much harder to enforce. Next slide, please. We'll go into each of those important 4 changes now. First, the agreement defined specific and very significant changes to the Mexican industrial relations system and reform of its labor laws that were a condition of the agreement. In other words, they had to make those changes in order for the agreement to go into effect. And they called for a fundamental shift away from the existing corporatist system in Mexico. I'm sure you all know the idea of corporatist labor relations, where government employers and workers collaborate to control the terms in the agreement. That is not necessarily a bad system, but over time in Mexico and some other places, but certainly in Mexico, it had become corrupted and unrepresentative of workers' interests. That was partly because the government, as I said, from the 1980s had shifted in a neoliberal policy direction, and wage repression was an important part of their policy. But also the dominant unions, there were independent unions, but the biggest and the most dominant unions were aligned with the governing party, the Institutional Revolutionary Party, PRI, and they accepted a collaborationist approach, including the system of wage repression and guaranteeing so-called class peace, meaning no strikes. In addition, both the government and some of the unions became increasingly corrupt, such that many of the collective bargaining agreements that exist, over 500,000 of them in Mexico, were actually what are called protection contracts or ghost contracts. They were signed between the employer and a corrupt union, or the employer and even just an individual lawyer, without any organizing or assent by the workers. The workers didn't even know they had a contract, didn't know they had a union. And those contracts basically simply restate the federal labor law minimums. So it just guarantees that the workers will get what the law guarantees that they will get, but it prevents them from getting another union or from striking. The current government in Mexico estimates that 75%, up to perhaps as many as 90% of all the collective bargaining agreements in Mexico are such ghost contracts. So the labor law reform basically shifts labor relations to a more democratic form of union representation, and what might also be called a more class-based system, where the union represents the workers' interest and the company's interest, and these are not necessarily identical, certainly not in every case. And it's also therefore potentially a more confrontational system. It shifts from the old corporatist Mexican system to a system which is rather more like the US and Canada, with many important differences, but at its core, it's more like the US and Canada systems. The 2 most important aspects that guarantee that is that workers were given the right to vote for their union officers, which they had not previously had. And they were given the right to vote whether to accept or reject their collective bargaining agreement, the existing ones that are there now, and every renewal would go to a worker vote. So worker democracy, worker control of their unions. And then the USMCA also specified very tight timelines for that to happen. The law had to be adopted in 2019. There is a 4-year transition. during those 4 years, every contract has to be voted on by the workers. Now, a very, very important aspect of this, which is not on the printed page, but is the reality of its position in the overall USMCA, is that a failure by Mexico to not only implement, but to maintain these legal reforms can be enforced through the USMCA state-to-state dispute settlement mechanism. And if a violation is found, sanctions can be imposed. So this is critical and path-breaking. This had never existed before, where a labor law reform, even one that was negotiated in the context of a trade agreement, could actually be made binding through an international enforceable agreement. The significance of this is that if a future Mexican executive or legislature is hostile to workers' interests, they cannot make retrograde changes to this new democratic system of rights without risking their all-important access to the US market and Canadian market. This was a lesson that the US learned the hard way. At the time that the US-Colombia Free Trade Agreement had been negotiated but couldn't get approved by Congress, there was a decision to negotiate between US and Colombia for some very important reforms to Colombian labor laws, to their labor ministry, to their enforcement system. And I was involved in it. I was in the Obama administration at the time. The agreement was very important. It called for big changes. They were implemented for the most part in the first years. However, a new government came in later that repealed or ignored those reforms, and it was not enforceable because it was a side agreement. So the importance of Annex 23 in the USMCA is that it binds the Mexican reforms and the rights of the workers, at least to the extent that it can be enforced through an international agreement with some serious economic consequences. Next slide, please. Another very important innovation is the rapid response mechanism. This is a mechanism that was created to address violations at the firm level. It exists in addition to the state-to-state dispute settlement mechanisms that apply to all chapters of the USMCA, including the labor chapter. This creates this new mechanism directed at the individual firm, actually at the individual factory or facility of the firm, if there is a denial by the firm of workers' right to organize or to bargain collectively. If there is such an allegation, which can be initiated either through a public petition or can be self-initiated by a party government, there will be a very rapid process of investigation by a neutral panel of experts. And if those experts find that the allegations were true, that in fact there were these denials of worker rights, the factory or facility will face the tariffs above those of the USMCA. So tariffs that had been reduced by the agreement will snap back to the MFN rates. And in the case of repeat offenses, their products can be refused entry into the complaining party's market. Next question, please. Next slide. Let me see, where am I? Third, the other important innovations in the labor chapter, the two that just I mentioned, the labor reform in Mexico bound by the agreement and the RRM are probably the most dramatic and path-breaking. However, the other very important innovations also include an explicit obligation for the parties to address violence or threats of violence against workers directly related to exercising their labor rights. Again, a lesson learned the hard way. The US took its first and only arbitration case under an FTA against Guatemala under the CAFTA. There was a great deal of violence involved, but it was not covered by the agreement. And so the backdrop of the violence was not considered admissible. Whereas USMCA says no party shall fail to address cases of violence or threats of violence against workers, and that's enforceable through the agreement. Second, there is an explicit recognition of the right to strike as an essential aspect of freedom of association, which had not been explicitly stated previously in the agreements. Third, there's a requirement that each country's labor laws must extend their protections not only to domestic or national workers, but to migrant workers. This was strongly pressed in the negotiations by Mexico. And there are new measures against gender discrimination, which were strongly pressed by Canada in the negotiations. And finally, the agreement closes some of the loopholes that were found in NAFTA and subsequent labor chapters that made it very, very difficult to win a case that went to arbitration. I won't go into the details on what those loopholes were, but if people are interested, we can come back and take a look at that. Next slide, please. So how are these important new obligations being implemented, particularly the reform by Mexico, and how are they being enforced under the agreement? So let's start with Mexico's implementation of the labor law reforms, since this is really a foundational change for the country and it's such a critical element of USMCA. The required changes were passed by the Mexican Congress in May 2019. It's just interesting to note that the previous administration, Peña Nieto, had introduced the constitutional reform, which was adopted just as Trump was coming in and quitting the Trans-Pacific Partnership. It had gone through the constitutional reform, all of the main points of the labor reform that I talked to you about, but it had not had implementing legislation. And the Mexican system is a classical system where a constitutional right has to be translated into specific legislative terms to become operable. And that had not been passed, but once López Obrador took over and his party, Morena, won a majority in both the lower and upper houses of the Mexican Congress, the reform was adopted. And it envisions a 4-year transition period to full implementation. So we are in that period now. It will be completed in May 2023. So we're about 2/3 of the way through the implementation period. The law creates new independent public institutions and courts, both at the federal level and in each of the Mexican states, and this is well underway. The law divided the states into 3 tranches that would create their own courts and institutions over the period of time. 2 of the tranches have already fulfilled their obligations and created the state level institutions. There is 1 more tranche, which is due to make those changes in May of this year. However, the Labor Ministry has just asked the Congress for a 5-month delay for a variety of reasons. And so now they're asking for the final set of 12 states to establish the institutions in, let me see, it would be October of 2022. So I want to emphasize that there has been good progress on building these institutions. And one of the important reasons is that there is a political alignment between the orientation of the US and Mexican administrations cooperating on this. So both President Biden and President López Obrador are pro-worker, and their relevant ministries have the support of the leaders to proceed expeditiously, even when they run into some opposition. And in Mexico, they have. The US government has also provided very substantial technical and financial support for the construction of the new institutions. For example, funding a project for information technology that will digitize all of the collective bargaining agreements in the country, all of the key union files, all of the statutes of the unions, and put them online and make them available to workers. So there will be transparency and accountability. So that progress is impressive, but it must be said that in practice, the Labor Ministry and the new independent Federal Center for Labor Conciliation and Registration, which is the body which will oversee the organizing and collective bargaining processes, don't seem to be adequately equipped to effectively enforce the new rights, either in terms of the sheer numbers of staff available, which fall far short of what would be needed, or even in terms of understanding the realities of this new system, which, as I say, you could think of as being less collaborationist, less corporatist, more class-based, potentially more confrontational. And the institutions, responsible institutions that are being created there don't seem to have a full understanding of the reality of what those labor relations look like in the workplace. And they don't really seem to be fully prepared to deal with the resistance that they're meeting from some employers and from some of the corrupt unions. So a great deal more work needs to be done before most Mexican workers will feel the effects of the reform. And in particular, there's a widespread need for public and worker education about the new rights and the new regime, because the capacity of workers and the trade unions to claim these rights in practice means they need to know and understand their rights. They need to believe and trust that the government will enforce those rights and protect them if they're violated. And so much work needs to be done there. And here I want to mention that both the Canadian government and the US government and Canadian unions and US unions are providing support in this regard, and that deserves attention. And I'll come back to it, and hopefully some of the people on the call can tell us even more about that. So yes, a lot of progress. Institutions are being set up. The law was reformed, but one could not really say that workers are currently enjoying the reforms that they were entitled to. And that brings us to the question on the next slide, please, of enforcement under the USMCA. So if there are violations, what happens with these new institutions and new rights? So the very first dispute to be brought under the USMCA, even before the dairy dispute between the US and Canada, the very first dispute was a labor case that was brought under the RRM. The US initiated it. It didn't come from a petition from workers or the public. It came directly out of the government. And the US Trade Representative asked Mexico to review an alleged denial of workers' rights at a General Motors truck facility in Silao, Guanajuato. The case arose when workers at the plant were voting on whether to approve their existing collective bargaining agreement. As I mentioned, during the 4 years from 2019 to 2023, all collective bargaining agreements have to be voted on by the workers to see if that's the agreement that they want. And when the workers went to vote on the agreement at the GM Silao plant, there were a number of irregularities. The existing union was affiliated with the CTM, one of the long existing unions affiliated with the PRI, the former party, Institutional Revolutionary Party. And the irregularities were so severe and deeply flawed that Mexico accepted it as a case under RRM. And the two governments then sat down and negotiated what to do about it. They agreed that the election should be rerun. It should be rerun with close supervision by the Mexican authorities, which had not been happening in most of the other votes. In many of the votes, there was no government presence, only run by the unions themselves that held the contract or by a notary. But not only did US and Mexico agree that the Mexican government, the labor ministry should have close supervision, but the ILO was invited to observe and sent a delegation of 15 observers. The labor ministry inspectors and the ILO representatives actually were in the plant for weeks before the election to ensure that workers were not being intimidated. And the new vote actually occurred in August of this year, last year, 2021. And the workers rejected that contract. Subsequently, a group of workers in the plant who had long opposed the existing union, which they felt was corrupt, and the existing contract, and had really led the campaign to reject it. They had been a movement, but now they formed themselves as an independent union, and they have petitioned the government to certify them as the new representative. However, 3 other unions, 2 affiliated to the CTM and 1 which had never been heard of before, have since also petitioned for the right to represent the workers. And so there will be an election February 1 and 2 to determine which of the 4 unions has the greatest support. There have been some very strong allegations of continued impropriety by the company and the CTM unions, and the independent union has called for the government to exercise oversight to correct these problems. We don't know what the outcome is. The election is scheduled for February 1 and 2. The second case to be brought under the RRM was a response to a petition filed by the AFL-CIO and a group of Mexican and US unions in May 2021, alleging that Tridonex, which is a US-owned automobile parts factory, had dismissed 154 workers who were trying to form an independent union, where another union that they claimed was corrupt already held the contract. So based on this petition from the unions, the US asked Mexico to review whether the workers had been denied their rights. This is a facility, by the way, in Matamoros, Tamaulipas. But after the review, Mexico refused to accept the case as an RRM case because the underlying events had occurred before the USMCA came into effect. So the US government subsequently negotiated directly with the US-owned company and reached an agreement. The agreement provided that the company would pay severance pay and back pay to the fired workers and make a commitment to neutrality in any future union elections. But it was rather controversial because it did not involve reinstatement of the fired workers. And in that case, the dissident union is also pursuing the right to represent the workers through other mechanisms under the labor law. So 2 cases so far. What can we conclude from these early cases? First, both were settled within a few months of the charges being filed. And for cross-border labor cases, this is unprecedented speed. Under any trade agreement or international regime, I would never go that fast if it were a case brought before the ILO committees of experts. And so the rapid aspect is definitely there, at least as has been the experience in these first 2 cases. Second, the US government was willing to press these cases against individual firms, whereas it had never taken a case against the Mexican government for non-enforcement of labor rights during the entire 25 years of NAFTA. It was not that allegations had not been made. It was not that some of the problems I described earlier were not known to exist, had not been documented. But to take a case against the Mexican government meant to add tension to a relationship that might have spillover effects. And I think this illustrates why the firm-directed mechanism, the RRM, which is firm-specific, can truly change the calculus facing governments when they decide whether or not to enforce the worker rights contained in their trade agreements. Third, I think the process, I described a bit of it, has highlighted areas where the Mexican labor authorities need support and even pressure to ensure that the democratic rights of the workers are respected. It's a profound change in labor relations, and it's going to take time, I think, to really show its effect. After the GM and Tridonex cases occurred and were publicized in Mexican media, widely publicized, workers then rejected existing collective bargaining agreements that they found unsatisfactory in several other factories that were either nearby in the same region or in the same sector, so that workers had heard about it. And so there does seem to be some signaling effect at play. But Mexican unions will need time and support to build up their capacity, both to organize and to negotiate robust collective bargaining agreements. And here I want to come back to something that I mentioned earlier, is the support from the US and Canadian governments and US and Canadian unions. Canada recently gave a grant to Unifor, which is the Canadian Auto Workers Union, of course, as you know, and a grant to the Canadian steel workers to set up offices and to form relationships and to help Mexican unions, presumably in their sector or related sectors, to develop the skills to use the tools that have been created in the labor law reform and under the USMCA, and to share their experiences. I hope we'll hear more about this during the discussion period, because I think we may have some union representatives joining us. In the US has provided support to Solidarity Center, which is the arm of the AFL-CIO that provides support to workers in developing countries. So the US government has given significant additional funds to Solidarity Center, specifically to expand its presence and its work in Mexico. And I think that this work, this cross-border labor solidarity, labor education, will ultimately, or can ultimately in any case, prove to be very important to the final full impact of the reforms that were negotiated. It puts tools in the hands of workers, and now they need to be They need to learn to use them, and sharing these experiences cross-border, I think, is going to be very important. Just before we go on, I want to mention that to understand what's happening in Mexico now in the labor sphere, you have to step back and see the wider picture of other reforms. As I said earlier, the López Obrador administration in Mexico is pro-worker and generally aligned with the labor goals of USMCA, but they have also taken a number of other very important steps autonomously, not required by the agreement, to improve wages and working conditions in Mexico. And I just want to mention a few because I think it's part of the reality that needs to be understood. So from the time López Obrador took office, Mexico has minimum wage increases. If they have one, it will happen in January. And so he took office in December 2018. In January 2019, with his leadership and influence, the Mexican wage setting institution raised minimum wages 16%, pretty dramatic increase, and doubled the minimum wage along the border where most of the maquila factories are, many maquila factories, because the cost of living is higher there. So either doubled or 16% increase in January 2019, an additional 20% in January 20, an additional 15% in 2021, and now an additional 22% this year. Compounding means that minimum wages have almost doubled everywhere in the country and more than doubled in the border region. These kinds of increases in minimum wages are unprecedented in any other country except China. And in China, they only began in 2003. It was a conscious decision, and they continued straight through until Chinese wages, now minimum wages and manufacturing wages, are significantly higher than Mexican wages. So Mexico, in a sense, is following that pattern, and some other countries I might mention, Vietnam, Cambodia, are also following the pattern of very rapid increases in minimum wages. So this is significant because in addition to the rights of workers to have accountable unions that bargain on their interests and can raise their wages, there's also upward pressure from the minimum wages. Another important reform is that the López Obrador administration, and with his party controlling both houses of Congress, adopted a very important reform to subcontracting, which forces companies to bring workers onto the main company payroll if they perform the usual work of that company. In other words, a very sort of remote responsibility that's not the core business of the company can use contractors, but anybody who's doing the normal work of a company, those workers have to be considered employees. And in fact, many thousands of workers have gained that status since the law took effect last summer, and they are now receiving minimum wages at least, and they are receiving the social benefits that are guaranteed to employees and other protections of the labor law. And already this year, there are further reforms proposed in the Congress to address platform workers, delivery workers, drivers, to insist that they be treated as employees, to make them employees, and also to address the wages of agricultural workers and export sectors. So many important changes going on. I think a backdrop of a very positive picture, but still a long way to go. Next slide, please. So does the USMCA represent a new generation of labor social clauses? Is it going to be the model? From everything I've just said, I think you can tell that my view is that it's much too soon to judge whether this is a successful model. But I can say a few things from the US perspective. There is likely to be path dependency going forward, as there has been in the past. The US learns lessons, sometimes slowly, but for example, the flaws in the agreement that led the US to lose its case with Guatemala, those were repaired. The fact that the Colombia Labor Action Plan was not enforceable under the agreement, that has been repaired by putting the by the annex on Mexican labor reform into. So there was learning, but there will be path dependency that will incorporate those reforms going forward. Second, I think it's quite likely that, again, we will see, as with the case of Mexico, that if you have countries where there are well-established deficiencies, not in the opinion of US trade negotiators, but as recognized by the ILO experts and by labor advocates in those countries, you will see demands that the laws be reformed as a condition for ratification, that they have to happen before the agreement can be ratified, and they have to be enforceable. So I think that innovation we will see repeated in the future. I think that the firm level dispute mechanism, the RRM, is likely to be included. It may have to be tweaked based on experience. There may be ways of improving it, but yes, I think that we will see that to be included. Whether this represents a new model for Canada, I wouldn't venture, but I think there are probably people on the call who have views on that and hopefully will share with us. And I would just say, in terms of the European Union, I just happened to make a presentation on the USMCA and the changes in the labor clause at Sciences Po here in Paris. And so I was on a panel discussing the USMCA, and then there was a panel discussing the current ongoing process of debate in the European Union about whether and how it should reform its approach to the social clauses, the trade, what they call it, trade and sustainability clauses. And so there were representatives of the European Commission, European employers, and European unions. The European Commission basically said, well, we're studying this and we really can't say anything more than that. We're having a dialogue. The European Employers Association said, oh, we like the model that we have now. We don't want to see any changes. And the European Trade Union Confederation, the ETUC, said, we love the USMCA model and that's what we want. That's what we want Europe to do. So that will become part of the debate in Europe. Again, we can't answer this question. Is it a new generation, a model for the future? But I think that we are beginning to assemble the elements, the knowledge, and the experience that we can start to address that. So let me stop there, and happy to take any questions, but also eager to hear from the Canadians who know very much about this topic.
Thank you very much, Sandra, for this presentation. Really interesting. So it will be the time for question from the public. So I suggest that you can raise your hand with Zoom to if you have any question on the presentation. No question? So I will start myself with a first question. You speak about second generation reforms. So what can you say about this second generation reform? What are they, and what is the difference with the new agreement?
Okay, so the second generation, so if we take NAFTA and the NALC as the first generation of a labor agreement, the second generation, both as negotiated by US and as negotiated by Canada and some others, I see Pablo Lazo is here, and by Chile, at least parts of it, but keeping our focus right now on North America, US and Canada both decided that the labor side agreement, not being part of the main agreement, not being enforceable under the main agreement, was part of its weakness. There was general agreement that the NALC was very weak for many, many reasons, but the fact that it was a side agreement was seen as a problem. So beginning with the very next agreement that the US negotiated, which was with Jordan in 2000, the labor agreement was put into the main agreement, and it was made enforceable under the same terms as any other chapter or part of that agreement. And Canada took that same step in 2008 with, I believe it was a Peru agreement between Canada and Peru. They did the same thing, bringing it into the agreement. Another very important change is that in the NAFTA, the parties drew up a list of what they considered to be important labor rights that should be addressed in some fashion by the agreement. As I recall, there were 11 labor rights, but they were divided into tiers, some of which could be enforced through an ad hoc settlement mechanism that was created in the Nalt-Side agreement, some of which could only be discussed between the parties, but nothing could happen. And some really didn't qualify for any real attention except perhaps a public conference or something. But that list was drawn up by the parties. And even before that, the US in its general system of preferences had a list of labor rights, but it had been drawn up by the US. What changed in the second generation, and this was very important, is that in 1998, for those who don't know, at the ILO, the member states and unions from all of those states and employers from all of those states agreed what's called the ILO Declaration on Fundamental Principles and Rights at Work, which says that there are 4 basic rights: freedom of association and collective bargaining, freedom from forced labor, freedom from child labor, and non-discrimination at work, that these rights are so fundamental that they apply to all workers, whether or not those countries have actively protected them, whether or not the countries have ratified the ILO conventions that describe those rights in detail and specify them. They apply to all workers, and that by virtue of membership in the ILO, all countries agreed that they had to respect and realize those rights. So now after 98, there was an internationally agreed reference point for what labor rights should be included. And so yes, in Jordan in 2000, again, I was involved directly in the negotiations. We referred not to the list that we had sort of willy-nilly drawn up in NAFTA, but we referred to the ILO declaration rights. And Canada began to do that, and now consistently Canada and the US both refer to the declaration. The EU also does that in its social clauses. So I would say, Sylvain, to your question, the 2 big differences: the labor clauses are right in the agreement, enforceable like everything else, and they refer to internationally agreed standards, so they aren't seen as picking and choosing by a particular government. I think those are the most important changes. A lot of other things were added. I mean, some are more bells and whistles about procedures to be used, but I would say those were the biggest changes in the second generation.
Thank you very much. I saw Yannick raise his hand.
I will put my camera, so a bit more polite. My question is about, well, I've not been following this debate since a few years, but I was there earlier on. And one of the complaints about this social classes, labor classes was that it didn't bring a lot. And I think your assessment was somehow confirming this. I'm happy to see that there are some improvement. My question to you would be, how long do you think it's going to take before it gives some results? And my question, I have a problem, not a problem, but how can I say that? I see some optimism in the firm-to-firm mechanism that is implemented, and it could somehow circumvent the diplomatic issues between the 2 countries happening. But regarding, for example, the thing that you said about the fact that there are some clauses that a government cannot undo a labor reform that was done, don't you think that it's going to be the same? I mean, if, I don't know, Mexico has a right-wing government coming in, they removed the labor law, it's not going to be okay with the agreement, but again and again, it will be a minor issue in the bigger overall relation between Mexico and the US, and it's going to be sidelined. No, am I too a pessimist?
Well, very, very good points that you make, Yannick. Let me take your second one first and then go back to the question of how long will it take. Yes, I mean, in a situation where a government changes party control of an administration changes parties, a very different philosophy, and there is a determination, for example, in some right-wing government to roll back the labor rights. Would they do it in light of the constraints that the agreement imposes on them? Well, they could do it, but they could face real economic consequences. So let's just take the example of Mexico. Suppose a government comes in that says, we don't want workers to have democratic unions that go into the workplace and advocate strongly for workers and raise wages and so on. So we're going to go back to a corporatist system, or we're going to just abolish these rights. Workers don't have any rights. Unless at the same time there was such a right-wing government in the US that didn't care to enforce, there could be serious economic consequences. What kind of economic consequences? Well, let's just take the example of the GM Silao plant. They produce trucks, pickup trucks. The most favored nation rate to import pickup trucks into the US is 25% tariff. The NAFTA rate is 0. So if the US decided, because you have gone back on this, we're going to reinstate our tariffs, in the case of trucks, that would be a 25% surcharge, which means that they can't export to the US. It's a very real potent tool. It does depend on the will of governments. There's no question about that. And that brings me back to the point that I made and that you referred to, which is the facility-specific rapid response mechanism is important, because it would be somewhat easier for a government to say, we won't tolerate these abuses of worker rights. And so we are going to say that GM Silao will have to pay 25% tariff. And if they continue with the problems, the denial of rights, we will simply stop their exports to the US altogether. That's a lot easier than to say, we will stop all exports from Mexico into the US, or we will impose all tariff, most favored nation tariffs on all Mexican imports. That's an enormously different political calculus for a government to make. And I think the fact that we have already seen 2 cases in 1 year and 7 months of the USMCA tells you how much easier it is for a government to make a decision to go forward. Now, partly that's the complexion of the Biden administration, but partly it's because it's a much more realistic step that a government can take. How long will it take to get results in this? We see some results. I suppose we'll see the end of, not the end of the story, but we'll see the full denouement of the advantages that were given to workers at the GM Silao plant. We'll know that in a matter of weeks or months. We'll know, have the tools created by USMCA, the new labor reform, the new rights, and the RRM, have they actually allowed these workers to have a union that represents them? We'll know that fairly soon. We'll know it in individual circumstances. How long it takes for a cultural change to happen in Mexico, where workers more broadly understand these rights, develop the tools and the skills and the tactics to implement them, that will take longer. And that's where I think this collaboration between Canadian and US unions with their Mexican counterparts could really change the dynamic. It could really accelerate learning and cooperation.
Thank you.
Thank you. Really pleased to see Pablo in this conference. So Pablo, you have a question?
Yes, thank you. And thank you. I take profit to thank the organizers of this conference, so interesting. And to thank you, especially Sandra Polaski for his marvelous presentation. Hello, Sandra. And I see Michelle Ryu and Pierre Bouchard and even Ken Curtis participating. So I say hello to them as well. My issue is that when I was formerly negotiator for the labor clauses in the government of Chile, we were pushing this kind of labor clauses, not as hard as the one Sandra described in the USMCA, but we were successful to put some language for the first time with China and other countries in Asia and in Latin America, when this was strongly opposed by most employers and some governments. The try we made was to convince about the importance of having compliance with the labor issues and environment issues along with the trade agenda and investment agenda, because it gives legitimacy to the economics and allows the trade agenda to advance. Now we have turned to the right government during 4 years, and now we are coming to a new progressive government. But they are not quite convinced about having trade agreements, because especially there is strong, powerful guarantees to the investment companies and foreign companies coming to the developing countries. And there is a strong rejection of that idea in many ways, especially because the investment chapters have some articles making prevail the provisions of investment protection rather than any other issue on the whole agreements of the FTAs. And there are some people raising the questions. We saw that this morning, and labor and environment issues raised by some countries that have put language or created laws because they feel, some companies, that they have been subject to expropriation, direct or indirect. And this was raised also in New Zealand during the TPP negotiations and so on. So I have a reflection that this gives a problem to the continuing of the free trade agenda and of the investment general agenda as well in the global forum. And my question is for Sandra, what is your feeling about this kind of contradiction that could appear between investment chapter and labor chapter? Because in investment, there is no way to expropriate companies, and direct or indirectly. And in the labor chapter, we are forcing the countries to improve their labor regulations. So what is your comment on this global issue that affects, in fact, the global social contract, I think, that we are developing here with up and downs during the latest history? I don't know if my question was clear enough, but my English is not as good this time, but that's it.
No, I think your question was very clear, Pablo. I think I understood it well about the tension between investment clauses and labor clauses. Let me say that investment clauses really have grown into monsters. Investment clauses in trade agreements and in bilateral investment treaties give rights to investors which are stronger than the rights governments give to their own companies, to their own domestic investors, and to any of their other citizens. It gives investors the right to go to private courts and sue governments for regulations that can include, as you say, labor regulations, minimum wages, social regulations, environmental regulations. The investment clauses have really become monsters, and many, many governments are rolling them back. In fact, the USMCA dramatically rolled back the investment protections that existed in NAFTA precisely because they were so perverse. They protected investors above all other interests. So as of 3 years, which will be a year and a half from now, there will be no investor-state dispute settlement between Canada and the US. And with Mexico, it will be limited to a few issues. I would have preferred to see it also eliminated between Mexico and the US, but it will still exist in some energy sectors with Mexico. But so there is this impulse to say, yes, these investment clauses were bad policy, they were bad economic policy, they didn't draw investment, they exposed governments to huge liabilities and risk, and they should be eliminated and completely rethought. Now, a lot of developing country governments have also come to that conclusion. India is renegotiating all of its investment treaties because it found them to be unbalanced and inappropriate. And there are many other countries that are following along that line. I know that it has been an issue between Canada and the European Union in the context of their negotiations, and they took some steps away from it. So I think you're absolutely right to identify that there is a potential conflict between the investor rights and the labor rights. And the solution is strengthen the labor rights as we have been doing, but completely revise the descriptions of the rights of investors and eliminate investor-state dispute settlement. It has no place in a proper balanced international governance system. I don't know if my point was clear.
Very clear, thank you.
Thank you very much. Is there any other question? Yes, Pierre?
Hi, everyone, and hi, Sandra, Pablo. I see some old friends here. Nice to talk to you, and thank you for this, Sandra. That was really interesting. Maybe because there was a reference to what Canada can do. I know this is being recorded, but hopefully I'll try to be careful. But it's always difficult for me. But hopefully I'm not going to be quoted on any of this stuff. But I mean, a lot of it is factual. I mean, yes, I mean, I agree with you, the evolution of the agreements, but maybe on a few things. The reason for non-enforcement of the NALC, you kindly mentioned only the US, but we've received the same criticism over the years that the NALC wasn't enforced. I mean, you described the tiering system in the NALC. The reason the NALC wasn't enforced wasn't at all, at least from the Canadian point of view, was never, and I've been on this file since 2004, and I've studied the cases since before I came onto this. The fact that no case ever went to dispute settlement under the original agreement had nothing to do with political calculation, at least for Canada. The original agreement was just deeply flawed legally. As you explained, no cases could go beyond ministerial consultation if it didn't fall into the types of rights that could go. There were a tiering system and ministerial consultation, committee of expert, arbitral panel. And then you have 3 categories of right. And at the end of the day, the only one that could really be enforced in an arbitral panel were like health and safety and child work for children and that sort of thing. So, and I think over the years we had done some analysis, and over 70% of all the cases received over the years by the 3 countries on the NALC were related to freedom association collective bargaining. And sometimes you would have reference in the case that the main complaint was about that, freedom association collective bargaining to health and safety and minimum wage, but nothing strong enough to go to dispute settlements. I would challenge anyone that would say that original complaints were not enforced to show us which complaint, which case could have realistically been taken to dispute settlement. Because we couldn't. I mean, and we're not going to take a case that we know is going to fail just for the sake of taking it and just failing. And that's even worse. Now, what government could have done is, instead of agreeing, that I could agree, instead of agreeing to these action plan over the years with Mexico that were really fluffy and didn't lead too much, they were completely different from the kind of action plan that the US or Canada negotiated with Colombia, for example, as a result of complaints or other countries. Government could have just said, no, we disagree. Mexico is not enforced, but we can't do anything, and just leave it there and leave, tension if you wish. But we just couldn't do anything. The other thing, when we mentioned that we moved from side agreement to to chapter. Yes, we did the move eventually, but legally that had no impact whatsoever. You can have a weak labor chapter and a very strong side agreement. I mean, I commend, and Sandra, you were on this, the original one with Jordan in 2000, and the first time you broke the ice there of having that agreement. But of course, it was the first one, and there was, and you know, there were improvement after that. But the EU, Chile, I'm sorry, Pablo, you did really good stuff over the years in your circumstances. I congratulate, but you know, you could have, well, they were mostly set agreements, but you can have a labor chapter or a sustainable chapter that is non-enforceable. Whereas we negotiated side agreements with Colombia and Peru. Yes, we had a chapter, but the chapter wasn't enforceable. All the obligations went aside. So yeah, so eventually that was a request from stakeholders that we moved to chapter. We did it. It wasn't a big deal, but we did that thing. And so, and now on this, the rapid response and the models. One thing I would say is, you know, I mean, we mentioned, there was two things that was mentioned. Are we going to include annexes in the future that are country specific? And are we going to include rapid response? So first of all, on the annexes, yes. I mean, if you follow the negotiation, I'm not revealing any inside information here. You can read that in Inside U.S. Trade, you know, and see how it went. Of course, Canada wasn't in the room when the chapter was negotiated. We were there, not the chapter, the annex with Mexico and the rapid response. That was pretty much done by the time there was a negotiation between the three countries. And then it just went US-Mexico. And then at the end, Canada joined back in after the deal was pretty much done. And the text was there, both the annex and the rapid response. On the annex and repeating that, I mean, that goes very far for a country to ask another country to do specific changes. And our approach, rather than this, has been to say, because what you're doing here, you're unilaterally telling another country, you must do these changes. And I could point to some clauses in that annex that maybe the US is not in full compliance with itself. And so practices in the US that are not acceptable in Canada. And so the approach we've taken is that, you know, as it was alluded in the press, Canada tabled an extremely ambitious text in the NAFTA negotiations that went much beyond you know, what was accepted. That text continues to be our approach. We're going to, of course, improve it as we have a bunch of negotiations that are about to start. So, of course, we'll look at if there are some improvement we can do based on NAFTA. But they were things that we tabled, including, and it was revealed in the press, including an obligation to ratify the core conventions and have them reflected in labor laws. The footnote 3, is still there in the CUSMA that basically puts that Chinese wall between the declaration and the conventions. So we put that in. It was reported that we put in very specific clauses. So we put a whole article in there with very specific clauses to go after right to work in the US. Of course, it was not accepted. We put very specific clauses that without, it wasn't naming the US, it was just the practice. We put very specific clauses as well that addressed directly protection contract and practices in Mexico without saying that it wasn't Mexico. We even put clauses that addressed other phenomena that we've seen in Colombia and subcontracting and that sort of thing. So I think there's a way to have a very ambitious agreement that actually the text that we put on the table on the level of obligation would leave even the CUSMA labor chapter right now in the dust in terms of the level of obligation. It goes way beyond that. And we hope to be able to conclude with a country so you can all see that text. But it's much more ambitious in the level of obligations. So I think there's a way to do that, but to do that in a fair way, in the sense that if we ask another country to take on certain obligation, we must show that we are willing to do the same in Canada. And finally, on the rapid response, I think, you know, of course, it's something, I don't think it's not something that government wanted. I mean, it's something that came from the US union movement. And for good reason. I would say the reason was probably the union movement in the US and similarly probably in Canada saw our traditional agreements where, if they have a problem with a specific firm, for example, GM in this case, well, under the traditional agreement, you must show there's a pattern and not a single case, and that it's a systemic problem in the entire country. The whole process takes time, even in the best of circumstances, 2-3 years to go through the full dispute settlement and be able to impose sanctions. So I have to admit, it is a long process and cumbersome. Whereas there, if you are able to target specific plant, it might be that plant in Silao that took production that were made in Windsor or in Canada before of specific trucks. So that's more direct. So we can see the benefits of that. I wouldn't say that it's easier for government to enforce that, because when you talk about all parts or the full trucks or cars that can be not just put the duty, but ban completely. That goes very far. You can ban the import on a third strike of the rapid response. The same company, third time that they lose before a panel, their whole export, this case, for example, GM, or could see their whole export to the country banned. That could have huge impact on production chain. Whereas if you use trade sanctions, the country that used the trade sanction is able to pick the area of the trade sanction that will least damage itself while putting maximum pressure. So I would say that, but I would leave you with that thought, maybe that question that we need to think of. Not that we're opposed, but frankly, right now, the rapid response, there's no definite position, but there's a big question mark for us first of all, there's a matter of weight. I think only the US, by putting its full weight, was able to push through that door, including the annex. So these would be very difficult things to get another country to agree to. But finally, there's a conceptual shift in what these agreements are supposed to be. The labor chapters are about addressing the labor laws in other countries, the content and the enforcement of that labor law, and solving issues at a systemic level and making sure the government is responsible for having those right laws and enforcing it. So you resolve the whole issue in the country. It's a big ask, but that's the idea. I have been in negotiations where the other country, which I won't name, actually told us, you know what, we don't have the ability to enforce our own labor law. If you want to go and hit individual companies that are bad actors, go and hit them. That was scary. When you have another government that basically gives up on having the right labor law and enforcing them and say, do it for me. And so the rapid response, are we in a sense privatizing the enforcement of labor law by bypassing the state, even if there's a linkage, of course, between the rapid response and the annex for Mexico, but basically going after individual companies. Now, we've had a couple, one successful case. The other case, as you pointed out, was in rapid response at a Tridonics case. But let's say if that multiplies by 10, 100 cases after there's a resource issue, I'm very curious to see how a panel would work. The timelines are incredibly, fast. But we have to think about this. Are we chasing now individual companies? How many companies are there? And are people losing interest in trying to address systemic problem and going through the labor chapters? I think that's at least a question we can consider. Thanks.
May I just make one comment specifically on the last set of issues that Pierre was raising, which are very valid and interesting in terms of, well, it's not privatizing because this is not done by a private company against a private company. It's done by a state, the state who's in the complaining position in the agreement. The US was the complainer, not the private party. So it's not privatization. But on your point on the resources involved, I think it's important, and I probably should have mentioned this, the goal with creating a penalty for the individual firm to violate its workers' rights is the same philosophy that you always follow when you are making laws and regulations, and that is to create a deterrent which is sufficient to get people to comply with the law voluntarily. And the rapid response mechanism with the reinstatement of the full tariff or even denying access to the market for repeat offender companies, the purpose of that is not for the US to run and do the enforcement for Mexico. The purpose is to create a deterrent for companies that want to exploit the weaknesses in labor enforcement in Mexico, want to exploit the low wages and the weak labor relations system, create a deterrent. Now, if companies, 1, 2, 3, 10, over the course of a few years, actually lose their access to the US market or pay much higher tariffs, I am quite sure that their competitor companies are going to be much more careful about not violating those worker rights, because the cost of losing the market is higher than the cost of paying workers what they're entitled to under the law or negotiating in good faith with them. So we're trying here, I mean, the underlying objective of this kind of penalty, as with any kind of a law and a penalty, is to create a deterrent effect. And I think that this is a strong enough clause, and Pierre is right. It took the muscle of the US to push it through. I mean, this has never been seen before. But if this model can create a deterrent, then we actually have made some progress in terms of how do you get companies to decide that they want to be in compliance with laws and with worker rights.
Thank you. Olivier raised his hand.
Yes, thank you very much for your presentation. It was very, very interesting. I have a question concerning the EU. You mentioned it at the end of your presentation. Has the US opened the gate with this kind of new approach to labor rights? Has the US opened the gate for the EU to do the same thing, relating particularly to Mexico, since the EU is still under negotiation for a new trade agreement? Or is the European Union going to stick to its the approach that it has at the moment, which is basically some kind of a name and shame system that it used rather successfully with Korea a year ago?
Well, I think I said all that I could say about what the EU is likely to do, based on having just heard from the Commission and the employers and the unions there that, again, the Commission said, well, we're studying it. The employer said, let's not make any changes. And the union said, let's have a USMCA rapid response kind of an approach. So I don't know what they'll do. In fact, I believe that the EU-Mexico agreement had been signed, but it hasn't moved forward to ratification. So it's possible that you could still see changes to that, but I simply don't know. I'm not close to that process.
Is there any other questions? No? Maybe I have a provocative question, maybe for Sandra, maybe for Pierre, that is a negotiator in chief for Canada in the trade and labor topic. So is it better to have 3 or 4 files a year and really documented files to make apply the new agreement? Is it better to have 100 of files a year to push Mexico to apply its new labor law?
Let me try to answer that. I don't think that that's a choice that confronts the US, that there are 5 or maybe it's 100 really strong cases that it can pursue. And this goes back to something that Pierre said. You know, it's not so easy to gather the evidence that demonstrates, even if all the people who live in that town know it to be the reality. To win a case in an arbitration, state-to-state arbitration, you need some very strong evidence. And so I think the approach of the US, probably under the Biden administration, will be to move forward with any cases that have a very strong factual basis to support the claims, the allegations that are made about the denial of rights. And if it's 5 in a year or more than 5 or less than 5, I think it will depend on workers in Mexico claiming that their rights have been violated, and then the US or the unions themselves or their partners among Canadian unions, US unions, developing the evidence that supports the claim to go forward. So yes, you're thinking about a strategy that you would purposely try to do something in order to to make the case and in fact to create the sort of deterrent effect that I was talking about. But I don't think that will be the decisive factor. I think it will be whether cases arise that are strong enough for the government to feel that if I raise this case, if necessary, if we have to go to either a panel, if it's the country, or the expert committee, if it's an individual facility, is this case convincing? The US doesn't like to lose cases. I can tell you that the loss to Guatemala was a very painful lesson for the US to learn. A lot of people, including me, who was involved in negotiations over the years, who were told we needed to say in our agreements that there would only be a penalty if the violation occurred in a manner affecting trade. And from Jordan on, I was resisting that. Many people were resisting. Why do we have to link it? When you go forward on intellectual property rights, you don't have to prove that it was in a manner affecting trade. If there's a violation of other clauses, you don't have to prove that. Why is that? But it was very strongly felt, and in the political sausage making of negotiating these things, it was always in there. And that is why the US lost the case with Guatemala, because a panel said, well, you didn't prove it. Yes, these worker rights were violated, but you didn't prove that it affected trade. Well, how would you prove that it affected trade? They wanted invoices that would show that somehow there was a cost advantage. I mean, things that simply were not available. There is no subpoena power. So, yes, I think that there is learning. People learn from their experience. And so the ability to deal with some of the issues that Pierre raised, that cases didn't go forward, at least that Canada didn't take cases forward under NALC because they didn't have the evidence. Well, I think that closing the loopholes and making it easier when there is a prima facie violation of worker rights to be able to go forward without these loopholes, I think is one of the important improvements of the USMCA, closing those loopholes.
Thanks. Yeah, it's funny to me when you say 3 or 4 cases or 100 a year, because 3 or 4 would be a lot for us. And yeah, because you need to gather this evidence. But just as a reference point, so you understand how these things can balloon, is, look at the forced labor ban. That was actually an obligation to CUSMA that countries must have in place. And Canada did put that in place. When the CUSMA came into effect on July 1st of 2020. When we negotiated that in 2019, there were about 12 shipments that year stopped by CBP. The year after, 324, I believe. Then now this year I think they're well over or going toward 1,000 cases probably of shipments, not specific cases, but shipments. So these things can really explode. And then you can ask yourself the questions about, how is forced labor defined exactly, and so forth. So this is I think Sylvain's a good question because, right now we have a few cases, but again, these could balloon, and we, of course, we have to answer and investigate each individual cases, and they can go pretty far. I mean, maybe a question to Sandra. If we want to be provocative, I mean, would the US ever agree that this mechanism would apply to itself? Because right now it doesn't. Just like, I'll be honest, that it doesn't really apply to Canada. It's supposed to be a bilateral rapid response mechanism, but there's a footnote in there that pretty much makes sure that when it comes to the US and Canada, all we did is we copy and pasted the entire agreement. We just copy and pasted what the US did. And as it applies to Canada and as it applies to the US, it will be almost impossible to bring any cases against Canada or the US under the rapid response. So it's basically a unilateral mechanism. And Mexico was forced to accept that. And so, would the US actually agree in the future that the same latitude and that it would be equally enforceable to the US by having the same kind of criteria of how it applies to Mexico? Because again, we've seen that over the years. The US will go with action plans and now with annexes where it will dictate to other countries. But then when we tried in the negotiations to raise the level of obligations, then the US is pretty clear. What they put on the table is a floor and a ceiling, not willing to go higher, where we're willing to go higher, but for both sides, so that that's something to consider.
Well, let me say that in terms of the rapid response mechanism, except for a footnote, yes, it looks like it's an entirely bilateral agreement, which is enforceable both directions, Mexico toward the US, US toward Mexico. All the terms are the same, except for a footnote, which says that Mexico can only bring a case after, in the US, for a denial of rights, after the denial of rights has already gone through the National Labor Relations Board and has been subject to an enforcement order. I can tell you that the advocates for the rapid response mechanism, and I was one of them, were not at all happy with that exception. But when those negotiations were going on, who was sitting in the US government seat? It was the Trump administration. And we were not able to persuade them. I believe that if that negotiation had happened 2 years later, when there was a different president, I think that we would have been able to get something that was more binding on the US. And frankly, the advocates for this are not looking to have an unequal relationship. The advocates, the labor rights advocates, want these kinds of pressures to apply to the US as well. And God knows the US needs them because of the weaknesses and loopholes in its own labor laws.
Thank you. Is there any question? So, yes, Marley?
Sorry, it took me a minute to make myself visible on the camera. First, let me start by thanking Sandra, thanking all of you for this just wonderful program, event, presentations, really, really outstanding, top-notch and terrific, and very, very thought-provocative. I want to follow on with something that I think Pierre was hinting at, and it is really the question of how much cumulatively are we moving labor rights in conjunction with trade toward an agenda that has harder and harder enforcement mechanisms. And this also goes to what Sandra was saying about the importance of having strong enough mechanisms so that they deter violations at both government and employer level, and in fact incentivize, quote, voluntary, unquote, compliance. And I think the forced labor regime, where goods are stopped at the border, is a really strong example of that. That is to say, if you cannot get goods made in any respect with forced labor into the American market, then supply chains are just going to shift, or the countries in which pieces of the supply chain are located are going to change their levels of compliance, and the businesses are going to change their levels of compliance. And so the question is this, together with the CUSMA, CUSMA, AKA the USMCA, is this a part of that trend? Can we capture what's going on here? And this also fits with Pierre's remarks about harder enforcement mechanisms in some of the agreements that Canada is working on. Is this a part of a move toward a much stronger version that says that all of the prognostications that increased trade was going to improve labor conditions and labor rights is going to become a reality, or is going to at least be mobilized under trade law to try and make it a reality?
I hope so. I hope so. I mean, again, just to go back to the notion of in public policy, why do you impose fines for violations? And why do you set fines at certain levels for violations of laws? You set fines because if there was no cost to breaking laws and having externalities, harm to other people, if there was no cost to it, a certain number of people, individuals, companies would do that. But if there is a cost to it, that will deter them. And you have to set the cost high enough that it's a real deterrence. If it's a very small cost, they feel, I'll just absorb that and go ahead. And making stronger enforcement provisions and stronger penalties in trade labor agreements is operating on precisely that same principle. The penalty has to be bad enough that it actually leads those companies to make the decision not to violate the worker rights because they don't want to suffer the penalty. That's precisely why we're doing it. I mean, I think you made the case more clearly than I did.
You made a great case for it, let me just say. I really congratulate you.
And I would say on our side that yes, absolutely, as a negotiator for over 17 years now, I've seen an evolution in Canada. It's not particularly linked to any government. I can see a broad evolution of consensus about having stronger labor rights in trade agreement. And, frankly, many years ago, it was basically told, go for it, negotiate the best, but don't be the last person standing between us and a free trade agreement. And so fortunately we got the deal, but these days I am personally surprised. I mean, to see, and I won't say the cases, but again, if you read carefully the papers and all this, you can surmise what it was. But I've seen the government walk away from negotiations because we couldn't get strong enough labor clauses. And so you can see the debate in Canada over the forced labor. It's no longer about our obligation in CUSMA. Everyone wants us to match the US action here and now. And when I say everyone, it's the media, it's every political party. It's, so, and the same thing, like for the rapid response, frankly, we're watching very carefully. If we have a case, but not impossible at all. And I can tell you, I have no pressure not to self-initiate. We could self-initiate, but again, we would need to have a very solid case. And if we come across solid evidence of that, we probably would. But again, we wouldn't want to lose a case. But yes, if I look at my world, I've gone from a world of always be the one fighting for enforcement. And now I'm watching the forced labor where goods are being banned altogether from entry. Rapid response, potentially, this is immediate. This is not like in the best case of a 3-year process for trade sanction. This is immediate sanctions, targeted sanctions on the company, potentially blocking goods. I mean, Jesus Seade, the chief negotiator for Mexico, at some point during the negotiation was quoted in the press by saying, this rapid response, Mexico might be better off not having a trade agreement altogether because they could still export to the US. But under this, Mexican export could be blocked of some companies, whereas export from Bangladesh or another country where conditions would be way worse than that could still export, but without the trade preference. So yes, there's a definite shift. And I think government understand that the public wants strong enforcement and strong labor clauses for these trade agreements to continue. And I would note the US did this really strong agreement, and I think others mentioned it here, and then basically just walk away. I mean, which trade negotiation is the US involved in? You see that's a big task. To put this nice big model out there, and the US then just pulls out of the free trade negotiating game, for now at least. And now it's difficult for us, I'll be honest. Many of the breakthrough Canada did in the past is because we came in after the US, Colombia, Peru, Honduras. We came in after the US has basically, smashed the door and created precedent. And we walked in after and said, me too, and let's do a few improvements here and there. Without the US in the game, and the EU is not a player because the EU has non-enforceable agreement. It's more harmful than anything else. Then it's very difficult. I am facing negotiation with ASEAN. Now look at the list of countries in there. Indonesia has a separate negotiations. And we have others in Europe coming up. These will be the toughest negotiation in my career. And we have no benefits of the US being out there as well supported. Plus the TPP accession process that's held there. So yeah, it's an interesting but very challenging environment as well.
Thank you very much. Any other question? So I will conclude. Maybe Michel, will conclude with me? I don't know. Is Michel there? No? Thank you very much for this presentation and for the discussion. I saw a lot of people we have met in other conferences in the last decade, and I was really pleased to see all of you in this virtual conference. So thank you, Sandra, for your presentation, and I wish that everybody has like this conference, and I invite you to see all other conference from SEIM that will be in a virtual or mixed way in the next month. Thank you very much.
Thank you, Sylvain. It was good to see you and all of the people participating.
Thank you.
Merci, Sylvain.
Au revoir.
Au revoir.
Au revoir.
Merci.